So we thought we'd do gender self-identification as an initial topic. And Lydia and I are going to talk about that. And I think it's interesting that it's one of those topics where when you look at a few of the recent cases, what's quite characteristic is that the EAT is very, very careful about how it expresses and articulates its views. There's a great quote from Forstater there from the president about not being seen to take any particular stance in relation to views. And there's a similar dicta in another case we'll look at. And that's a reflection of the fact that what we can see, whatever views one has in the particular area of gender, that there are very strongly held views which are articulated with a high degree of vehemence. And only a brief foray into the world of Twitter will see that expressions on either side of particular views will prompt quite vehement reactions in either direction. Now, in the context of the employment field, that, of course, raises significant problems and risks in the workplace, not least because of the need to respect people's expression of their beliefs and thought patterns, and the ability of others to work together in that particular environment. So to deal with this, we're going to break it down into a couple of sections. I'm going to look at some of the terminology. Terminology is challenging because terminology changes. What can be accepted usage for some groups at one point in time can change to be perceived as being unacceptable and prejudicial. We're then going to look at the question of the protective structures in relation to legislation in this particular field. Lydia's going to deal with that. I'm going to deal with the issue of conflicts of belief and how tribunals are dealing with that. And then Lydia's going to come back and talk about some of the practical issues in the workplace. So just starting off, we need to look at some of these specific concepts. The starting place is assigned birth gender. So we're looking here at the gender that is assigned to an individual at birth, generally being male or female, and generally on the perception of physical characteristics. Oh, Mrs. Reade, it's a boy. So assigned at birth. I have to recognise at this particular point the existence of intersex persons with an anatomy that doesn't fall into the characteristics of either male or female. And then quite separately, we have to identify the concept of biological sex, not entirely easy or free of debate as to the scope of biological sex. Maybe simply a question of chromosomes, X and X, X and Y, maybe a combination of chromosomes, hormones, and physical traits. But biological sex is distinct from assigned at gender, assigned at birth. Obviously, in the majority of cases, biological sex and assigned at birth will align. We then deal with the concept of gender identity. And we picked up here a quotation from the Yogyakarta Principles on the application of international human rights. This was a convention of jurists who looked at a definition of gender identity, not formally adopted within the context of the Human Rights Commission, but it's helpful as a working definition when we look at identity. And gender identity they defined as being each person's deeply felt internal individual experience of gender, which may or may not correspond with the sex assigned at birth, including personal sense of body, which may involve freely chosen modifications of bodily appearance or function by medical, surgical, or other means, or expressions of gender, including speech, mannerism, or dress. Now, if we look at gender identities, that's where we find that gender identities may differ from assigned gender at birth. So one may have someone whose gender identity, that sense of gender, is different from that at birth, and we're using the description trans to describe that as an individual. As I say, that seems to be the accepted form of usage amongst those who perceive their gender identity as being different from their assigned identity at birth. Now, gender identity may not be as simple as male or female. There may be a gender identity which is non-binary, and that non-binary may have a perception that one's gender is on a continuum, and maybe at different points in that continuum at different times. At some points they may identify as female, at some points they may identify as male. Equally, there may be a gender identity that has no perception of gender at all of these differing from a gender assigned at birth. And the concept of transitioning is the concept of having had an assigned gender, but having acquired or affirmed a different gender from that assigned at birth. We also just need to identify, because of the language usage, cisgender being used to identify someone whose gender is assigned at birth and their gender identity is the same. Perception assigned at birth, female. Gender identification, female. Cisgender. So we also have, slightly differently, and Lydia is going to talk about it in the context of protection, gender expression, slightly different from one's own gender identification, the choice of how one expresses a gender, dressing, for example, in the gender which is different from that which has been assigned, a male dressing as female, female dressing as male. But that's an expression of gender rather than an acquired or affirmed gender necessarily. We then just need to look at a bit of the legal structures in relation to this. We have in the UK the Gender Recognition Act 2004, and the Gender Recognition Act 2004 is the act which enables an individual to legally change their gender, acquiring a new birth certificate with their affirmed or acquired gender. And presently, that act only recognises male or female. So if your acquired gender is non-binary, the act doesn't enable you to have a certification of a non-gender status. To get a certificate of gender recognition, you need to be over the age of 18. You need to show gender dysphoria, which the NHS describes as being a distress or anxiety about your acquired or affirmed gender being different to your assigned gender. It's not a disability, but it might occasion disabilities in the sense of depression or anxiety. But you need diagnosis that you have gender dysphoria and that you spent 2 years in your acquired gender. And now they've recently reduced this to £5. You pay a £5 fee, and you have to be evincing an intention to live permanently in your acquired gender. Those steps enable you to get the certification. If you have a certificate, then in law, for the purposes of the Equality Act, you are treated as having a gender that is your acquired gender. Lots of trans people do not wish to go through all of those hoops in order to acquire a certification. So there are many trans people that do not have a certificate. Worth just noting a bit of controversy at the moment, because obviously all of those steps are not as simple as the concept of saying, I now self-identify as being a different gender and therefore expect people to treat me as being that gender. In Scotland, we have the Gender Recognition Reform Bill. That contemplated a much simpler system for the purpose of identification, reducing it to age of 16 and relying upon self-identification of gender. That's been presently blocked by the UK government under Section 35 of the Scotland Act. I understand that the Scottish government is looking to judicially review that decision. And the UK government's rationale is that having such an easy system for gentrification, for gender recognition change, for certification, would have an adverse impact on the Equality Act, and in particular, single-sex associations or single-sex services in the traditional model. So we'll have to see where that goes. One thing about the certification is a certificate does not make it unlawful for you to be addressed in the gender different to that which you've been certified. The law, it creates a gender for the purposes the law in terms of the Equality Act. But as I say, many trans people don't have certification, and absent certification, the choice of being a different gender from one's assigned gender doesn't in law create any specific protected characteristic unless we fit within particular forms of protection under the Act that Lydia is going to address. Finally, before Lydia looks at the form of protection, she just mentioned biological sex. One of the quirks of the Equality Act is there's no actual definition of sex under the Equality Act. You think, well, would there not be? You just actually find the references are very, very narrow. There's a reference in section 11 to it being sex being a particular characteristic as a reference to a man or a woman and persons who share the same characteristic. And then if you trawl around the Act, you find in section 212 that man is defined as a male of any age and a woman as a female of any age. So we haven't actually got a specific definition. Very recently, the Equality and Human Rights Commission responded to a parliamentary question and said that they were thinking that it might be desirable to define sex for the purposes of the Equalities Act as meaning, for the purposes of the Equality Act as meaning biological sex. And they said that that would create legal clarity in certain areas, pregnancy, freedom of association for particular groups, lesbians and gay men, and in the context of single sex services, sport and data. They recognised that it would cause difficulties in narrowing the protection in relation to equal pay, direct and indirect sex discrimination if you only had a biological definition as the working definition. There's another problem, which is agreeing on how a biological definition actually works for the purposes of defining those particular terms. At the end, they said, we think government needs to look at this. And so I suppose there's a raising of the issue, but at the moment, there's no active agenda to challenge those particular points. So that's a structure of the language. We're going to look at how that fits into the legislative framework, which Lydia is going to take us to.
Very much. Yeah, well, I thought that was confusing. You should look at the full list of all the different name options, and we've just chosen the selected highlights for you. What I'm going to try and cover in the next section is looking at the protection that's available under the current legislation. And you already have gathered from the definitions and the terminology that David's taken us through that it's quite a complex area, because our understanding and our vocabulary and our expectations around this topic have changed considerably, even in the time since the Equality Act was introduced, but even more since the gender recognition certificate process came into play. And so this is an area which has to constantly evolve and move with the changing moods in society. Let's have a look first at Section 7 of the Equality Act. This sets out gender reassignment. A person has the protected characteristic of gender reassignment if the person is proposing to undergo, is undergoing, or has undergone, or part of a process for the purpose of reassigning the person's sex by changing physiological or other attributes of sex. So let's just look at that a little bit. And the second part is on the slide, you have it in your handout, but let's look at that a little bit. We've got some helpful advice from the code, which you could be said just restates what's in that definition, but let's look at it anyway. Under the Act, gender reassignment is a personal process that's moving away from one's birth sex to the preferred gender, rather than a medical process. So it's really emphasising, and indeed the second quotation makes the same point, this does not have to be a medical process. Reassignment could have been defined by way of looking at particular medical processes available, and if someone had gone through one of those processes, they would have the protection under the Act. It was not, and it is expressly not, and the definition where it talks about physiological or other attributes is intended to be much wider than merely a medical process. It's also absolutely clear, and the second point on the slide makes this point, that if you're proposing to go through a process, that's enough. You get the protection. If you have undergone it, or if you're undergoing it, you also get the protection. If you've undergone part of a process, you get the protection. So it's a very wide definition in that sense. If you make a change, for example, changing the way you dress or changing the name that you ask people to call you, as part of a process for you in altering the gender identity that you have, then that will fall within this provision. If you change the way you dress because you just happen to think that actually this is really comfortable or this is a great new style, that doesn't fall within the definition. So we've got a situation where two people can make the same change but for a different purpose, and one will get the protection and one will not. Both could be treated badly because of the decision they've made by colleagues or others. One would have protection under the Act and one would not, unless the one who's done it not as part of a wider purpose of reassignment is perceived to have done it for that reason. And then, of course, the perception-based discrimination provisions might come in and give that individual some protection. So we've got a situation where there's potentially some treatment which can fall through the cracks if there's no mistake about it, but the individual is not in one of these particular camps. Somebody could be treated in a way that is causing harassment, causing them to have a really unpleasant working environment, but they don't quite fit into the definitions. If, of course, somebody falls within the definition, they've got all the protection under the Equality Act that is afforded. Now, we might think gender reassignment and transsexual are a little bit outdated terms. They tend to, or they seem to infer there's a move from one thing to another thing. And if you've got, for example, a situation where somebody says, well, actually, I'm non-binary, I don't really think I'm one or the other, and I don't want to be put into a particular camp, the definition doesn't naturally follow and fit with that. Equally, if somebody says, well, I don't really agree with the concept of gender at all, and I consider myself to be somebody who is non-gendered, and I don't want to be addressed by any gender references, again, that doesn't really fit within the concept that we have here. We've seen from David's discussion that there are a number of different ways in which people can identify. I think there are over 60 different terms that are recognised. I mean, if you look at different lists, there's even more, but that describe gender or sexuality and go to this issue of gender identification. Simple notions of male and female moving from one to another don't really cover this broad diversity. I think of it like this, that I think probably at the time a lot of this legislation was drafted, people thought in terms of male, female being opposites, and they recognised that some people would move along from one to the other, and that they could get their heads around and they accommodated it. I think now the way people think about gender is we're assigned this gender at birth, and then it's more like a sun. You can go in any direction. It can end up in any different place. And that doesn't naturally fit with the thinking from 13 years ago or even further back. So some of these categories don't naturally fit within it. And of course, if you're not within it, then you don't get the protection from the Equality Act, unless, of course, we come back to that perception point. If other people perceive you to be in that category, then you would. It's because Section 7 is not really gender identity. It's reassignment. It's about a change. It's about one particular experience. However, when this was considered by the tribunal, we see, and we'll go through this case a little bit because it's a really important consideration of the provisions. So this is Taylor and Jaguar. The claimant was gender fluid. So we're in one of those categories which we've identified already, doesn't naturally necessarily fit within the wording of reassignment. The tribunal recognised there's no prior authority on this point. This claimant faced harassment at work, and the respondent's argument was that the claimant was not undergoing gender reassignment because she was gender fluid. She'd accepted in cross-examination she was non-binary. She wasn't heading to anywhere or going from a particular fixed point to another fixed point. And what the tribunal did is take a look back at Hansard to see the intended scope of Section 7. And there were some very telling quotes from Vera Baird, the Solicitor General, at the time. And the two that the tribunal really picked out that stood out to me were the quote that says, "It concerns a personal move away from one's birth sex into a state of one's choice." So we can see that in that quote, there's no intention of going in a fixed line to somewhere else. It can accommodate the sun description. It can go in any direction to end up wherever you choose. And the other quote that stood out to me was where they said, someone who has a gender identity, so someone who's reassigned, is someone who has a gender identity that is different from a person of their recorded natal sex. So it's not, again, it's not this idea that they have to be in the opposite identification, or there has to be these two fixed categories. It's just different, whatever different may be. And when the tribunal considered those 2 points, they reached a conclusion which warrants me reading it out because it's very well put. I believe that the note sections from our talk should have been provided to you. So hopefully somewhere in your pack, you'll be able to find this quote if you want it for later. But I'll read it out because it's very well expressed. We thought it very clear that Parliament intended gender reassignment to be a spectrum moving away from birth sex, and that a person could be at any point on that spectrum. That would be so whether they describe themselves as non-binary, i.e. not at point A or point Z, gender fluid, i.e. at different points between point A and point Z at different times, or transitioning, moving from point A, but not necessarily ending at point Z, where A and Z are biological sex. So you can see they're recognizing that this is not just binary in its choices. We concluded that it was beyond any doubt that somebody in the situation of the claimant was and is protected by the legislation because they're on that spectrum and they're on a journey which will not be the same in any 2 cases. It will end up where it does. I think that's an important sort of mindset to get into. It's not a destination. It can end up wherever it ends up. And then they concluded the wording of Section 7 accommodates that interpretation without any violence to the statutory language. So if you consider again the definition, actually, I'll just try and pull it back up for you on the slide so you can see it. But what's important here is that it actually talks about a person has a protected characteristic of gender reassignment if the person is proposing to undergo, etc., a process for the purpose of reassigning the person's sex. It doesn't say reassigning as what. And I think that's the important part, which when you think of it in the context of the time it was written, it's implicit as to where it's going. When we think of it now, the wording is actually broad enough to cover a much wider range. So, let's skip back. So, of course, their conclusion was that that is covered, and that's fabulous because that actually means a much wider category of people fall under gender reassignment than might initially have come across. It still doesn't necessarily fit for individuals who still don't want to be talking in gendered terms at all. They still may feel that doesn't fit with where they are, but it does expand the category of those protected. So there's just a couple of other provisions to cover very briefly before we look at the conflict between gender identification and self-identification and belief. The first of which I've highlighted is disability protection. Now, I need to be really clear here. In no way am I suggesting that those who have a different gender identity from their birth assigned gender are in some way disabled. However, for some individuals, they may have particular conditions which may amount to a disability. And if we're advising them, it's very important we don't miss this strand of the argument by getting lost in the gender identity point. So, for example, certain individuals with gender dysphoria or gender identity disorder may have depression, anxiety, etc., which is severe enough that it actually amounts to a disability under the Act. Certain individuals who are intersex individuals may have health complications arising from their intersex status, which may amount to a disability under the Act. And there is some evidence to suggest that gender dysphoria is actually more common with those from a particular, with certain disabilities. And so there may be an interplay there that needs to be explored with any client who's presenting with this issue. And I think it's important that we consider that because, of course, if our client has a disability, not only have they potentially got the protection under gender reassignment, but they've also got the scope for reasonable adjustments claims and arising from claims. And those can be really powerful claims to bring across for a client. So it's important that we don't miss that part of the protection. There's a couple of other provisions on the slide, far less interesting, but they're there. It's important we factor them into consideration. So provisions in relation to provision of separate facilities, which I'll talk about a bit more at the end. Prohibition on discrimination as a general prohibition, and of course provisions in relation to privacy. None of those are going to be a complete package of protection, but they may well help a particular client with a particular issue, so it's important that we keep them in mind. Now I'm going to hand back to David, who's going to tackle the thorny issue of where somebody's gender identity conflicts with the beliefs held by others.
Thank you very much, Lydia. Or indeed, the beliefs of the individual who has a gender identity different from their assigned gender, conflicts with others' beliefs. So this has been a vexing topic, and it's a vexing topic, I think, in this context. What we know is that a discrete area of protection under the Equality Act is protection under Section 10 for religious or philosophical beliefs. I think when I came back and revisited the notes, I thought I should have also added at this point, because they feature later on, that of course those also sit in the context of the rights under the European Convention of Human Rights, in particular Article 9, the right to have philosophical religious beliefs, and 9.2, the freedom to express those beliefs or religious beliefs, and Article 10, freedom of expression, both of which engage in tribunals in exercising their powers in relation to this field. But starting off with philosophical belief, just very briefly going back in history, you'll recollect that Section 10 was considered in a case called Granger and Nicholson, and it isn't simply a passing thought that's sufficient for the purposes of establishing a protected characteristic. It's got to be a genuinely held belief, not a mere opinion or viewpoint that might just be transitory on the basis of present information. It has to concern a weighty or substantial aspect of human life and behaviour, has to have a degree of cogency, cohesion and importance. So we're looking at structures of belief, and critically for this particular area, has to be worthy of respect in a democratic society, not incompatible with human dignity and not incompatible with the fundamental rights of others. Now that was very much the battleground when we come to two opposite sets of belief, and I've just summarized them very briefly. One set of belief being that gender may be different to gender at birth, and that trumps sex, so that trans men are and trans women, sorry, trans men are men and trans women are women. That's one view. The opposite view being that sex is biologically immutable and there are only two sexes, male and female. Those are rather stark articulations with many variants on those particular beliefs, but they're opposites, obviously. Oops, sorry. That's better. So that where those beliefs had particular focus is in the case of Forstater, and Forstater actually in the EAT was an appeal against a preliminary issue, the preliminary issue being whether or not the claimant enjoyed the protection of Section 10. And essentially the argument primarily focused on that last section, whether or not her beliefs were beliefs which didn't enjoy the protection of Section 10 of the Act, because of them being expressions of beliefs that were not acceptable within a wider community. That was a challenge in relation to the last section. Now, Ms. Forstater had beliefs that sex was biologically immutable. She'd posted tweets entering the debate about proposed changes to gender certification. She was a contractor for the respondent, and what happened is that she wasn't offered further work because people within the organisation made observations about her tweets being transphobic. Went to a preliminary issue. In fact, the preliminary issue took 6 days. Her witness statement articulating her beliefs, I think, was 60 pages long. And the tribunal found that she didn't enjoy the protection of the legislation, just going back because they considered that her views were views which weren't worthy of respect in a democratic society, being incompatible with human dignity and conflict with the fundamental rights of others. Now, the EAT addressed that, and what they identified is that that last condition is a very high threshold indeed. When you look at the legislation, it's contemplating an expression of belief which effectively is destructive of the rights of others. So beliefs akin to Nazism or violence or hatred against particular groups. Her views, however, some people might have found them objectionable and other people might have found they agreed with them, were nowhere near that type of level. And therefore the EAT concluded that it had to be the case that her views were protected. One interesting aspect of the reasoning is that, of course, under Section 10, it's not only a positive belief, but a lack of belief in something which can be protected. So, of course, not only did she have a positive belief that gender was defined at birth, she didn't believe the idea that gender could be changed by self-identification. And that was also recognised to be a belief. Well, it logically follows from that a belief that gender can be changed by self-identification is also capable of being a belief, depending on whether or not someone holds those views. So you can immediately see a problem. We've got two belief systems, both of which are completely capable of enjoying protection under Section 10. And somehow, in an employment context, if you've got people articulating those views, which are recognised might be offensive to the other group, but aren't anywhere near the requirement not to be given their recognition, causes a sense of conflict. We'll come back to Forstater because it went back and she succeeded at the tribunal, having had that preliminary issue. But I'm just going to briefly touch on Makareth and DWP, a subsequent case, because we see it reflected in Forstater when it went back on liability. We see how that balance can be struck and how one deals with it in the workplace. Makareth and DWP concerned a doctor who applied for a job working as a health and disabilities advisor, which required him to assess individual applicants for disability benefits. And he objected through his Christian beliefs to addressing service users by the pronouns of their choice. He only wanted to address people by what he perceived to be their pronoun of assigned birth, because he didn't believe that people could change their gender. And he brought claims for direct and indirect discrimination. The ET found that his beliefs weren't protected. We'll look at that very briefly. Importantly, he failed in his direct discrimination claims because the tribunal found that other workers who declined to address people by their chosen pronouns would have been treated in the same way. It's worth knowing that actually he possibly jumped the gun in terms of a claim, because he'd not actually been disciplined. All that the employer had done is asked him to understand his views and where his issues were, and he'd taken and treated himself as being constructively dismissed at quite an early stage in that process. And that was always a challenge for the direct discrimination case. He lost on the facts. Indirect discrimination we'll come back to. What's interesting on the belief system is that the EAT in Forstater said you had to look at beliefs quite carefully to define exactly what they were. I've set out what the summation of his beliefs were. You can see there were many elements of it, and the tribunal then spent quite an exercise in digesting the individual parts. Aspects of this they found to lack sufficient cogency, in particular elements B1, 2 and 3 and C, but importantly overall they found that, and this was a decision before Forstater, that it didn't meet the last condition, that these were expressions of belief that were reflective of which shouldn't have been afforded recognition in the wider community. Now the EAT considered those carefully and actually said that most of the elements of belief were really manifestations of belief, and really the core elements of his belief were A and B. And really that's all that he needed to establish was A and B. He only needed a core element of those beliefs. And following Forstater, inevitably they concluded that there wasn't a tripwire that meant these shouldn't be afforded respect by way of belief. So it's clear that he succeeded on that in the appeal. He failed on direct and indirect. It's worth just looking at the policy. The policy that he was bridling about was that the organisation had a policy that transgender customers undergoing any stage of transitioning should be treated with respect and referred to in their presented gender at all times, and that people should always address a customer using the person's name where possible rather than the person's gender. Now, he objected to the use of self-identified pronouns. The tribunal found that the organisation had legitimate objectives in this particular policy. They were concerned that they didn't want to ask people about whether they were transitioning, what their specific status was, whether they held a gender certificate or not, and they were concerned that it might be offensive to people when they're undertaking this delicate exercise, not simply to accept their pronoun of choice. Those were the objectives of the particular exercise. Now, the key point about discrimination on direct discrimination was that issue that we see in many discrimination cases about distinguishing between discrimination about the belief and manifestations of the belief. The treatment about how it manifested itself, refusing to do this, was not the belief itself, but a manifestation of it. That, following the case law such as Page, is capable of being not direct discrimination. So I may have a legitimate belief, I may have that belief respected, but if I choose to manifest that belief in an unacceptable, unreasonable way in the workplace, an employer who acts on that manifestation can legitimately act in relation to that. And as I say, here on the facts, there wasn't any actual conduct detrimental to him in the event about detrimental treatment, but you could see the line of travel if his conduct in manifesting itself expressed a particular viewpoint in an unacceptable way. Indirect discrimination then became his main focus. Well, the policy was causing me difficulty. And there the tribunal had to very carefully consider whether or not the objectives of the policy were legitimate. As I've identified, there wasn't disagreement about the objectives being legitimate aims about how they dealt with service users. It's really justification. And the battleground about justification was really whether or not it was proportionate. I should have said that that's where we get Article 9.2 and Article 10 of the European Convention on Human Rights engaging the same ground for a tribunal. Am I interfering with your legitimate expression? Is this a proportionate interference? The tribunal undertook a careful balancing exercise, recognizing that it was actually in very few cases that one found that there were trans individuals who were attending where there might be an issue about the pronoun, and they balanced that against the likely risks and impact of people being distressed in a difficult set of circumstances, or indeed harassing individuals by inquiring too closely about whether or not they were undergoing a process of transition or what their true identification of gender was. So the tribunal found that it was a justifiable policy. One interesting point is that it appeared at the AT that, of course, one of the things a claimant can do in arguing that something is not objectively justifiable as an indirect policy is show a less discriminatory method of achieving the same aim. By the AT, the claimant was arguing, well, actually, it would have been more effective if we simply had a policy to say use first names rather than desired pronouns at all. And that had some force because actually the claimant had no difficulty with that. The employer had no difficulty with that. They could have adopted that policy. But from the point of view of the claimant, that's an argument which he only latched upon to in the AT. He'd actually completely disavowed that argument before the tribunal, and the AT said, well, it's too late to run that argument now. But it will obviously be important always, if one has a policy that might be indirectly discriminatory against people with particular belief systems here, to say, is there a less discriminatory way of impacting upon people that we could operate the policy to respect people's legitimate expression of their views in the workplace. I've put here in the slides, I won't go through them, a couple of well-known cases been going on recently, Bailey and Stonewall, Randall and Trent College. It's obviously a very hot topic. There are several appeals now running. Forstater was refused permission to, McCreath was refused permission to go to the Court of Appeal, so Court of Appeal must have taken the view that that's a clear expression of the law. Forstater went back, won on liability, and has just had a remedies hearing about a month ago. Her articulations on Twitter seem to be direct discrimination in the refusal to offer her new contract. Tribunal looked at whether or not those manifestations were unreasonable or excessive, so that it was possible to act upon them as being manifestations. The tribunal concluded that they weren't. They were just expressions of her genuinely held beliefs, even if some people found them to be offensive. I'm going to now hand over to Lydia and practical issues in the workplace.
Thanks, David. Before I go on to practical issue on the slides, I think I missed a typo, and it's quite an important one. On slide 27, which David's just taken you through, the first bullet point says tribunal had applied page and concluded that another worker who refused to refer to service users in the manner of their choosing, but it should say did not share the belief. It's not is such an important word, isn't it? In this case, it's vital. So if you include the not, that will make a lot more sense. I hate it if someone's looking at it later and going, I don't remember that point, and this doesn't really make any sense. There you are, first practical issue done. Great. So I'm going to very briefly talk about some of the ways in which this manifests itself for our clients, whether corporate or individual. And the thing to remember, David, may I have the slide clicker? Sorry to be a pain. Second practical issue addressed. Good. First point, and where it will come up very often, and this is already clear from what we've talked about, is harassment. And obviously, if people have a gender recognition certificate, they may have some protection under Section 11 in relation to that. Somebody without a gender recognition certificate might be protected either based on perception or if they fall within Section 7 that we looked at earlier. I wanted to particularly highlight two examples of harassment in this area, which are bespoke to this area, and those are deliberate misgendering or dead naming. Now, for those who are not familiar with what these terms would mean, if somebody has identified that they wish to be known, either as he, she, or with a new name, which reflects their gender identity, and somebody deliberately, we're not talking about the accidental slip, which may happen when you've only just made a transition and people are adjusting to that. But if someone deliberately misgenders them, and that means using their old pronouns or using their old name, then that is defined under the code or highlighted under the code as an example of harassment. And it's really easy to see why, particularly in a workplace, if someone were to introduce their colleague by their former name, their dead name, to a new contact, to a new client. So that individual is immediately put in a position where they have to confront quite an important and quite personal aspect of their identity with somebody they've only just met. You can see how that creates a sort of environment which would fall under the protections under harassment. So that's an important one to be aware of. What do we do about it? Well, as always with these things, it's about creating a culture in which there is understanding and inclusion. We'll look at some of the policies and practices, but some of these are already very widespread. You can, for example, invite people to state their preferred pronouns on their email signature. If everybody in the organisation is doing it, or if many people are, then it's much easier for somebody whose pronouns don't necessarily match their assigned birth to do it without feeling like they stand out as different or not included. May not fit for every organisation, may not be appropriate to require everybody to do it, but it's an option and it's a very easy one and it costs nothing. Other examples might be, for example, including training in this area, getting experts and external organisations in to help facilitate conversations, particularly if there's an individual who is transitioning, and that will create an environment where it's not all about them, it's about a wider topic, and we want to embrace that topic and be part of that conversation. Possibly supporting things, pride events, other things that are going on that just demonstrate that this is something which is okay, that the organisation is comfortable with and happy to support. I need to talk about toilets. Some of you may be crossing your legs at this point anyway and thinking of toilets, so I'm going to go straight to the toilets. It sounds a bit bonkers, but most of the time, for most people going into work, in whatever gender they have identified with, they can go into work, they dress themselves at home, they choose how they express their gender, they attend work, they do their job. The pinch point comes when they need to use the facilities, whether that's changing rooms, showers, toilets, etc. At this point, suddenly we have a really gendered environment in the office, which forces people into a situation where either they use the facilities of their assigned birth and feel horribly uncomfortable that this doesn't fit them, or they use the facilities for their gender identity and perhaps feel uncomfortable that other people are not comfortable with them there, and it creates a tension. Well, the guidance is really clear. They should have the choice to use the facilities which fit the identity they have. And it's also clear now, it wasn't always, it's also clear now it's not okay to say, well, you can use the disabled toilet as an alternative. Because that's, again, it's that situation where you're making somebody othered and you're putting them in a campus saying, something wrong with you, there's a disability, I'm going to put you over there. That's not okay. Now, for some workplaces, it's quite easy. If you've got, as we have in Littleton, a whole load of individual toilets, it's very easy to say this is a male or female toilet. Anybody can use this one. It's also easy enough for us to say this one's a female-only toilet, this one's a male-only toilet, and these ones are male or female toilets. Because each of our toilets is an individual toilet. There's no complication there. For some offices, it's a bit more difficult. If you've got a bank of female toilets and a bank of male toilets, it might be a bit more difficult to accommodate it. Lots of guidance suggests cubicles in all the toilets, make them all gender neutral. That raises a concern for some individuals that actually having particularly a female only space is quite important. But there has to be a consideration about how you can accommodate this in the workplace. And actually, because it's a question of accommodating it, you know, if you're renting a building, you can turn around to the landlord and say, this is your problem, you've got to sort this out. You need to give us appropriate facilities here and you need to engage with us on this issue. As I say, the most important thing to note now is we mustn't just revert to the disabled toilet as the backup. And the final thing I wanted to cover is some practical areas on policies and procedures. So, for example, in recruitment, give people the opportunity to state their preferred pronouns on the application form, so that actually from the first moment of the interview, you can have that conversation in an appropriate way. You can be speaking to them in the way they'd like to be addressed. Having a culture of mentoring, introducing new individuals into the organisation, giving them a point of contact which enables them to discuss where they should go and who they should speak to about things. Best practice says that our work policies have got to encompass complex gender identities. We need to take every single policy, do a find, man, male, female, woman. And we need to consider, is that the right term to be using in that place? Is it necessary? Is there a more appropriate term which would actually be inclusive? And an awful lot of the time it's there for historic reasons and it can easily be stripped out. So we need to assess those and make sure that they actually are fit for purpose. We need to make sure our policies address some of the issues that David's just been speaking about, where there's a conflict about it. We need to be clear about where manifestations will cause issues, but where personal beliefs will be accepted and tolerated. And the last point on this slide, which I think is really important, and frankly, if there's only one point you take away from the whole of this session, it's that communication is key. And frankly, if there's only one thing you take away from all of employment practice, I would say communication is key. It's so many problems in the workplace disappear if somebody has a really supportive, open, and honest conversation about things. There's some really good guidance in the GEO Guidance Action Plan about if an individual is employed in the workplace and is transitioning, how do we deal with communication? And I think it's worth just highlighting some of the points that are in that guidance. Particular issues, the manager should encourage the individuals to describe what they think will be best for them. That's not rocket science, but it's missed so often. What would you like? What can we do to support you? It could be a verbal communication with the team at a team meeting. It might be one-to-one information. It might be with the individual present and leading it. It might be in their absence, but with an agreed communication. It's entirely up to that individual. It could be by email, or it could be much more of a group setting. The person may not want to tell anybody at all, in which case that needs to be respected and supported. Every situation is different. This is all from the guidance, but the communication needs to provide general awareness as well as addressing issues specific to that individual. And that's where some of those points about having external organizations come in, advise, lead a discussion, open people up to the correct terminology or different ways of expressing things. Everybody's on a changing and learning process with this. And I think we need to recognize that and not just assume that everybody will instantly pick it up from social media. Colleagues need to be able to ask questions and managers must set the right tone. Absolutely crucial. The communication also needs to be practical, and I think this is really important. It needs to look at how the individual would like questions to be answered. So if questions come in from the wider team who are not having this more detailed conversation perhaps, how would they like those questions answered? Questions come in from clients, how would they like those questions answered? If they're having time off for particular medical processes as part of this, how would they like that to be addressed, recorded in the diary? What's being said about this? Because there's a really important confidentiality issue on the one hand, and there's also the fact that when we don't have a dialogue about it, we get rumours and we get a situation where that harassment can occur unintentionally. So the important thing that emerges from all of that, it's not rocket science, but it's really important, is communication.